Be ready. Start. An order of acquittal in a case under the Prevention of Food Adulteration Act 1954 as amended by Act 35 of 1976, hereinafter referred to as the Act passed by the Chief Judicial Magistrate in CC number 145/79, is challenged in this criminal appeal filed by the Food Inspector on March 27, 1979, at about 9 p.m., the food inspector (PW1) inspected the food factory run by the respondent managing partner, the Tropical Fruit Products Allowed, for the purpose of purchasing a sample of a food article which the concern was manufacturing for sale. Accused 2 and 3 before the trial court are the other partners of this concern. The respondent was manufacturing in his factory synthetic vinegar, orange squash, etc. under a license granted by the local panchayat and also a license granted under the act. At the time of inspection, the respondent was present in the factory and PW1 found a number of bottles of vinegar kept for sale in the factory. In order to take a sample of synthetic vinegar, which is an article of food, PW1 served a notice in form number 6 in bracket Exhibit P2 on the respondent. Thereafter, he purchased one bottle of synthetic vinegar from the respondent after paying him its price. Exhibit P3 is the voucher issued by the respondent acknowledging receipt of its price. PW1 opened the bottle purchased by him and sampled the same in accordance with the provisions of the Act in the presence of witnesses and the respondent. The sample purchased by PW1 was divided into three equal parts and was filled in three clean and dry bottles, and each part of the sample was duly packed and sealed and labeled containing sample number 6 was pasted on each of the sample bottles. Everything enjoined under the Act and rules framed thereunder was complied by PW1. A Mahazar exhibit P4 was prepared on the spot, attested by two witnesses and also by the respondent. One part of the sample taken was sent to the public analyst for the analysis along with the Form 4 memorandum. The remaining two samples were forwarded to the local health authority along with two copies of Form 4 memorandum. An intimation as required under the provisions of the Act and the rules was sent to the respondent. On analysis, as per Exhibit P6, report of the public analyst, the sample was adulterated and did not conform to the standard prescribed for synthetic vinegar under the Prevention of Food Adulteration Act 1995. Thereafter, PW1 filed a complaint before the trial court against the respondent and two others who are the partners. Para. In support of the prosecution case, besides PW1, PW2, PW3, PW4, and PW5, the executive officer of the local panchayat were examined and documents exhibit P1 to P11 were marked. The respondent, when examined on the prosecution evidence, admitted that the Tropical Fruit Products Allowed is a partnership concern, that he is the managing partner and the two other accused are also the partners. As regards the evidence of PW1 that he purchased a sample of synthetic vinegar from the respondent, he admitted the visit of PW1 to his factory but stated that the vinegar was not kept for sale, that it was kept for testing and bottles were not sealed and labeled. He admitted receipt of Exhibit P2 notice and issuance of Exhibit P3 bill. The learned magistrate, on due consideration of the evidence, found that the article of food from which the sample was taken was intended for sale, but on the ground that the sampling was defective due to violation of Rule 22A of the rules framed under the Act, and also finding that the prosecution has failed to prove that accused 2 and 3 are in a way connected with the management of the firm, acquitted all the accused. Stop.